we have heard many times that it is impossible under international law to confiscate other states' sovereign property because it would be a violation of sovereignty principle. But isn't it already proven that when we can freeze them, it is already a decision which we have taken over other states' sovereign assets? So we can go just one step further and say, okay, we have frozen it, we can confiscate it. So what does really international law say about this?
There's no doubt, let's start with that about the illegality of Russia's invasion of Ukraine and the occupation of Ukrainian territory. By doing this, Russia has violated the most fundamental rules of international law that are in the UN Charter, which prohibit the use of force against the territorial integrity and political independence of another state. That is so fundamental. And this fact has been recognized not just by the United Nations in repeated resolutions, but also by the International Court of Justice, which ordered Russia in a binding ruling back in March 2022 to desist its aggression, which it didn't. So there's legal recognition that Russia is waging a war of aggression. That is not disputed in the Western world. It's also not disputed that under international law, Russia owes reparations for the damages that it has caused by waging this war of aggression. So Russia has violated two obligations, the aggression itself and the duty to pay reparations. So in the face of such a blatant violation of a state's international legal obligations, such as that Russia has committed, international law permits other states to respond with what's called countermeasures. The basic idea is that countermeasures are a self-help tool to enforce international obligations in situations exactly like this, where institutions, for example, the UN Security Council, have failed or they're defunct. What are countermeasures? Countermeasures are delineated by the UN International Law Commission's articles on the responsibility of states. These articles represent the most authoritative statement of customary international law on state responsibility. That they are the most authoritative statement that we have. They're frequently cited by the judgments of the International Court of Justice and other international tribunals. So they're the best statement that we have. Countermeasures are defined in these articles by definition as state acts that would ordinarily be wrongful, such as interfering with sovereign property. But the wrongfulness of that act is precluded because the action is taken against another state for its serious violation of international law. So what did I mean by asset freezes were wrongful acts? Well, typically, countries can't interfere with each other's property, and that includes freezing their assets. So asset freezes and asset seizures are both examples of countermeasures. So in this case, by transferring assets to an international compensation mechanism, or seizing them and then transferring them, states would cause Russia to comply with its obligation to make reparations to Ukraine. And that in and of itself would be a lawful countermeasure. I also want to bring up the point, and I think it's worth pointing out, that states have a positive duty, a duty to act, in other words, in accordance with Article 41 of the RCW, which says states shall cooperate to bring an end through lawful means any serious breach. They shall cooperate. This means that third-party states aren't only entitled to take countermeasures, they actually have a duty to do so. Ukraine is obviously entitled to take countermeasures because it was directly affected, and third-party states can as well. When a country's misconduct is so egregious, such as Russia's, that it violates the very core norms of international law, it's considered to affect the entire global community, and any state therefore has the right to take countermeasures against it. So just to put it in very simple terms, the idea is that no country can have it both ways. Aggressors can't violate every single tenet of the rule of law and then use it to claim protection for their property. That is countermeasures in a nutshell, and this is what international law says. So when people say, well, this would be an exception to international law, actually, no, it's not. It is international law.
These articles you're talking about, if I'm not mistaken, they clearly cite that they describe unlawful acts, which are in normal situation, you cannot do it. You cannot bomb another country's territory, but you can do it if that country has attacked you and you are in absolutely fair or defensive war. Or you cannot like kill other people, other nation soldiers, but you can't do if these people are invading soldiers who are on your ground. The same you can do with the property. Normally you cannot freeze it or confiscate it, but in a case of the aggression, you may do it because these wrongful countermeasures are countermeasures. But what I wanted to ask you, if I'm not mistaken, that in these articles they only are applicable as long as the United States Security Council has not spoken, and in this case it is what we have. But are these articles, as you say, are they binding for other nations? So can we say that other nations must confiscate Russia's assets, or is it what they may do not, depending on their political mood?
The first point I do want to clarify is that they're not just applicable when the UN Security Council has failed to act. They are not mutually exclusive. They're meant to operate in addition to the mechanisms of the UN Security Council. And that's because countermeasures are intended to be decentralized relations between countries. So any country or group of countries can participate in collective countermeasures, even if the UN Security Council has taken action. So that doesn't preclude it. What the articles do is that they basically govern relations between states, and any state can choose their relations to another country. So I just wanted to clarify that point, that they're not mutually exclusive. But in this case, they are even more important because the UN Security Council has failed its mission to bring about peace and to bring about stability in the world order. So our last form of enforcement really is countermeasures. But to your second question, the articles themselves say, under Article 41, it says that states shall take action to bring about the lawful means of an end of a breach of peace. Shall, usually, in legal terms, means a mandate. It means that they must cooperate and they must do this. However, the thing with international law is that it's not black letter law necessarily, it's customary international law. So it's determined by what countries view it as. So they may choose to abide by it, they may not, they may have a different view of it. So in practice, while it says that states shall cooperate to bring about an end to this aggression, the reality is that different countries have different views of it, and it's more a political decision than it is a legal one. And that's really at the heart of this whole issue.
How much is the possible actions of national states, sovereign states, dependent on their domestic law? I can imagine a situation when the international law allows or even encourages the countries to act, but their domestic law doesn't foresee any procedure or even bans states from doing that. What is the legal situation in, let me say, the G7 countries?
One of the main misconceptions, and one that the audience has probably heard, is that Russian state assets are protected by domestic sovereign immunity laws, and that seizing those assets would deprive Russia of due process under that whatever country's constitutional legal system. So that's the main obstacle that people usually cite as a barrier under domestic law. But I do want to clarify that, because that is a misconception. And that's because sovereign immunity and due process don't apply here. There's no immunity between sovereigns. What there is instead is state responsibility. This is what I alluded to with the articles, and that's what's laid out by the UN International Law Commission. Sovereign immunity, though, only shields a state from actions by foreign courts. And due process is a court-centric doctrine. Sovereign countries don't get due process under domestic laws because they're not a person, and their sovereign property is not the same as private property. So it's governed by two different sets of principles. So under domestic law, by transferring assets using executive action, sovereign immunity doesn't come into play. So what do I mean by that? Under domestic law, the countermeasures would be adopted and implemented strictly by the executive branch of government, or the legislative branch. In other words, the political branch of government, but not the courts. This would be a decision by the legislature or cabinet decisions in a parliamentary system. Some countries already have laws in place that could be used for something like this. For example, I'm from the US, so I can speak to US law. In the US, the president could, for example, issue an executive order. And this would be authorized under the International Emergency Economic Powers Act. But some countries don't have an analogous law like that, obviously. But that's the thing. That's the job of lawmakers. The job of lawmakers is to make the law. If a law doesn't exist to do a certain thing, then the lawmakers can draft that law. So to the extent that a country's current laws make it difficult to use Russia's sovereign assets to pay for the destruction that it has caused in Ukraine, lawmakers should work to change the law. It is that simple. Instead, but for governments to throw their hands up because the law as it currently is difficult, or it doesn't exist, or it prevents them from doing anything more, when it's them who make the law, I would say that that's a dereliction of duty. So to the audience, please don't let arguments that, oh, our domestic law just doesn't allow us to do this, stop necessary discussion, because the law evolves and the law changes, and this is what lawmakers are elected to do.